One of the most singular features of the jurisprudence of the Middle Ages, and one which was retained in the French Code down to nearly the middle of the 19th century, was the indictment of domestic animals for injuries inflicted on mankind. Records of the criminal tribunals of France disclose 92 such judicial processes between 1120 and 1741, when the last of these grotesque trials took place in Poitou. The practice seems to have been based on the Mosaic law, it being in Exodus ordered that, if an ox gore a man or a woman that they die, then the ox shall be stoned, and his flesh shall not be eaten. Oxen and pigs were the animals that most frequently were the subjects of these strange proceedings, the indictment against the former being for goring persons, while the latter suffered for killing and sometimes devouring very young children. The earliest instance of which any particulars can be gathered occurred in 1314, when, according to Monsieur Carlier, who relates the story in his History of the Duchy of Valois, a bull escaped from a farmyard in the village of Moissy and gored a man so severely that death ensued. The Count of Valois, being informed of the fatality, he directed that the bull should be captured and formally prosecuted for causing the man's death. This was done, and evidence was given by persons who had seen the man attacked and killed. The bull was thereupon sentenced to suffer death, which was inflicted by strangulation, after which the carcass was suspended from a tree by the hind legs. Next in the order of time comes the trial at Phillies of a sow which had torn the face and arm of a child, from the effects of which injuries it died. The sow was condemned to be mutilated in the head and one foreleg, and afterwards to be strangled, which sentence was executed in the public square of the town. This was in 1386. In 1457, a sow and her 6 young pigs were tried at Lavigny on the charge of having killed and partially eaten a child. The sow was convicted and condemned to death, but the little ones were acquitted on the ground of their tender years or months, the bad example of their mother and the absence of direct evidence of their having partaken of the unnatural feast. In 1494, sentence of death was pronounced on a pig by the mayor of Lyon for having mutilated and destroyed an infant in its cradle, 4 particulars of which case were given in the Lyon Annual for that year. The act of condemnation, as they're given, concludes as follows.
We, in detestation and horror of this crime, and in order to make an example and satisfy justice, have declared, judged, sentenced, pronounced, and appointed that the said hog, being detained a prisoner and confined in the said abbey, shall be, by the executioner, strangled and hanged on a gibbet, near and adjoining the gallows in the jurisdiction of the said monks, being near their copyhold of Avon, in witness of which we have sealed this present with our seal.
Judicial proceedings against the lower animals were not confined to France, for the list of such cases compiled mentions in the Journal of Antiquities, one tried at Lausanne in 1364, another at the same town in 1451, a third at Basel in 1474, another at Lausanne in 1479, and a fifth at the same place in 1554. The Basel case was a very singular one. A farmyard rooster was tried on the absurd charge of having laid an egg. It was contended in support of the prosecution that eggs laid by roosters were of inestimable value for use in certain magical preparations, and that a sorcerer would rather possess a rooster's egg than the philosopher's stone. Satan employed witches to hatch such eggs, from which proceeded wind serpents most dangerous to mankind. On behalf of the prisoner, the facts of the case were admitted, but his advocate submitted that no evil animus had been proved against his client and that no injury to man or beast had resulted. Besides, the laying of the egg was an involuntary act, and as such not punishable by law. If it was intended to impute the crime of sorcery to his client, he was entitled to an acquittal, for there was no instance on record of Satan having made a compact with one of the brute creation. In reply, the public prosecutor stated that though the evil one did not make compacts with brutes, he sometimes entered into them. The poor rooster was convicted and condemned to death, not as a rooster, however, but as a sorcerer, or perhaps a devil, in the form of a rooster. It was, with the egg attributed to it, burned at a stake, with all the form and solemnity of a judicial execution. Even more strange than the trials of oxen, pigs, etc., for offences against mankind, were the legal proceedings often taken in the Middle Ages against the smaller quadrupeds, such as rats. In 1547, legal proceedings were commenced by the inhabitants of a village in the Diocese of Autun against the rats by which their houses and barns were infested. The trial is famous in the annals of French jurisprudence as that in which Chassagne, the celebrated attorney, first achieved distinction. The rats not appearing on the first citation, Chassagne, who was retained for the defense, argued that the summons was of too local a character, and that as all the rats in the Diocese of Autun were interested in the case, they should be summoned throughout the diocese. This plea being admitted, the courier of every parish in the diocese was instructed to summon all the rats within its limits to attend on a day named in the summons, the day having arrived and the rats failing to appear. Chassagne said that as all his clients were summoned, including old and young, sick and healthy, great preparations had to be made and certain necessary arrangements effected, and he had to ask, therefore, for an extension of time. This also being granted, another day was appointed, but again not a single rat put in an appearance. Chassagne then made an objection to the legality of the summons. A summons from that court, he said, implied full protection to the parties summoned, both on their way to it and on their return to their homes. His clients, the rats, though most anxious to appear in obedience to the court, did not dare to leave their homes to come to Autun on account of the number of evil-disposed cats kept by the plaintiffs. If the latter would enter into bonds under heavy pecuniary penalties that their cats should not molest his clients, the summons would be immediately obeyed. The court acknowledged the validity of this plea, but the plaintiffs declined to be bound for the good behavior of their cats.